Power of directors are generally contained in the articles. Power of directors are contained in the articles, and there is usually a clause giving them the power of management of the company. There is usually a clause which gives them power of management of the company and all other powers which are otherwise dealt therein. This clause is, however, not to be construed. This clause is, however, not to be construed. Uh, is just damn generous, but it has been held to cover and render valid all acts of the directors done bona fide in the management of the company. Uh, the director of a company can do whatever the company can do, subject to the restriction. What is the restriction? Imposed. Subject to the restriction imposed in the articles of the company. Tata Iron and Steel Company Limited, AIR 1928, BOM 80. Directors have implied powers to do whatever is incidental to the business of the company. Though the members in general body meeting though the members in general body meeting decide to sell out the undertaking of the company, and directors, according to Kerala High Court, have powers to refuse the sale in exercise of their discretionary power of the board, if they feel that such sale is detrimental to the interest of the company. The power of sale of assets is vested in the board of directors, and they are responsible for the proper exercise of it. Pothen versus Hindustan Trading Corporation 1967-37, Com Case 266. The Companies Act lays down specific provision in regard to the powers that may or may not be exercised by directors and the manner of exercise of such powers. Section 291 provides that the board of directors of a company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to do. Section 291 provides that the board of directors of a company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to do. The effect of this section is that, subject to the restriction contained in the Act and in memorandum and articles, the power of directors are coextensive with those of the company itself. There are, however, two important limitations upon their powers. Firstly, the board is not competent to do what the Act, memorandum and articles required to be done by the shareholders in the general meeting, and secondly, in the exercise of their powers, then directors are subject to the provision of the Act. Memorandum and articles and other regulation not inconsistent therewith made by the company in general meeting. Powers The powers thus conferred on the directors are conferred collectively on the board. An individual director or director can exercise these powers only by delegation by the board. As and when a director is appointed as manager or managing director, or a special committee of the board is set up deal with some special work, the board shall not exercise any power or do any act or thing which is directly required to be done by the company in its general meeting. However, in exercising such powers or doing such thing, act or thing, the board shall be subject to provision contained in that behalf, in this or any other act, or in the memorandum or articles of the company, or any other regulation. Section 291. Where under the article the director enjoys full power of managing the business of the company, the shareholders are not entitled by resolution passed at a general meeting to give effective directions to the directors to the effect as how to manage the business of the company without altering the articles. This even cannot overrule the decision of directors in the conduct of the business. Consequently, the directors of a banking company are entitled to enforce payments of debt even though the general body passes the resolution to write off the debt. It is held in Suburban Bank Private Limited, Trichur versus Triyanath and another 1968, 38 Com Case 13. The entity of a company is entirely separate from that of the shareholders, and if a company does not possess a fundamental right, then its shareholder cannot be allowed to file a petition for enforcement of fundamental right on the ground that the company is nothing more than the association of shareholders and members. Prithvi's Cotton Mills Limited versus Borough Municipality and other, AIR 1968, Gujarat 124. The board shall exercise the following powers on behalf of the company, and it shall do so only by means of resolution passed at the meeting of the board. The power to make call on shareholders in respect of money unpaid on their shares. Power to issue debentures. Power to borrow money otherwise than on debenture. Power to invest the funds of the company, and power to make loans. However, the board by special resolution may delegate to any of the committee of directors, the managing agents, secretaries, and treasurers, the manager, or any other principal officer of the company, the powers specified in 3, 4, and 5 above, section 292. Even where there was no actual resolution authorizing a director to enter into a transaction on behalf of the company, either by the board or directors or by the board of managing agents, a claim of creditor could not be effected if the terms of its memorandum and article of association associated such a transaction. In such cases the person negotiating with the company is entitled to pressure that all the formalities in connection therewith have been complied with. Section C.P. Rangaswamy versus R. Krishnaswamy A.I. 1973, Madras 251 at page 253. Restriction on the power of board. The board of director of a public company or of a private company which is a subsidiary of a public company shall not, except with the consent of such company in general meetings, sell, lease, or otherwise dispose of the whole or substantially whole of the board of directors of a public company or a private company which is a subsidiary of a public company shall not, except with the consent of such company in general meeting, remit or give time for the repayment of any debt due by the director, except in the case of renewal or continuance made by the banking company to its director in ordinary course of business. Invest otherwise than in trust securities. Borrow money